Every person has a right to defend against any offense. We are talking here about a right to defend the body. Every person has a right to defend his own body, that's for sure, and the body of his relatives or the body of any other person, etc. These are the other options. The answer lies in section 797 of IPC. Every person has a right to defend his own body and the body of any other person. It need not be a relative, it need not be a friend, it need not be even an acquaintance, even a stranger is included here. The right to defend the body includes the right to defend the body of any other person, and any means any, including a stranger. And against what offenses? Against any offense affecting human body. Offenses affecting human body are enumerated in chapter 16, and all those offenses starting with 299 ending up to section 377 IPC will be included under section 97. So going back to the question, the correct answer will be option B, his own body and the body of any other person. Question 2. Under section 57 IPC, in calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for how many years? Now, section 57 IPC is a deeming provision. There are several provisions in IPC where fraction of a term of punishment is required. For example, when we compute punishment for abatement, punishment for attempt, etc. In all those calculations, imprisonment for life shall be taken as equivalent to imprisonment of 20 years. That is the correct answer. So wherever 1/4 of the imprisonment is required, it will be 20 divided by 4, that is 5 years. The relevant section, of course, is section 57, and the answer option here is option B. Question 3. Outraging the modesty of a woman is punishable under? It's a straightforward question. Answer is section 354. Outraging the modesty of a woman. This is section 354. You will notice here that what is required under this section for an offense is assault or use of criminal force. Intention is to outrage the modesty of a woman. It is not actually outraging the modesty of a woman. Actual outraging may or may not be there. What is required is just an intention to outrage the modesty of a woman, and with that intention, the act done is either assault or use of criminal force. Use of criminal force is defined in section 350, assault is defined in 351. What is required is assault and use of criminal force. Actual outraging the modesty is not required. From this section, we can see that actually it is not outraging the modesty of a woman. The offense considered under section 354 is assault or use of criminal force with the intention of outraging the modesty of a woman. So that point needs to be kept in mind. As far as the answer is concerned, quite simple. Option C, section 354. Question 4. The right of private defense of property against theft continues still. Once again, a straightforward question. The answer lies in section 105 of IPC. Right of private defense of property against theft continues till the offender has effected his retreat with the property or assistance of public authorities obtained or the property has been recovered. Section 105, you need to remember the section, and the right continues till any of these three things continue. Question 5, defamation. Defamation is both a tort and a crime. It is a crime under section 499 IPC, and it's also a civil wrong, a tort. You can approach a civil court, you can also approach a criminal court. So the option is B. Question 6. A 28-year-old man and B, a 27-year-old woman were in a romantic relationship and were living together. After being in a relationship for nearly 3 years, A asked B whether they could have sexual intercourse. B said that she would consent to sexual intercourse only if A agreed to marry her. So there is a clear condition from B. She would give consent only if A agreed to marry her. The next part is A promised to marry B, and thereafter they had sexual intercourse multiple times over the next 3 years. So they were living together, they had regular sexual intercourse for the next 3 years. Subsequently, B discovered that A was not being faithful to her and was in a relationship with another woman. She broke off the relationship and sought to initiate criminal proceedings against A. Which of the following offences can A be prosecuted for? Cheating, criminal breach of trust, custodial rape, adultery. Now going by the process of elimination first, adultery is ruled out. Why? Anyone can tell me? Why should we rule out adultery? Yes, Smita, you can switch on your audio also, or you can type it out. It's not a marriage, that's what Shruti says, but yes, for adultery, what is required? Yes, the correct answer is the offense of adultery has been struck down. It is no more an offense. It has been held to be unconstitutional by the Supreme Court, and therefore we can straight away rule it out. Even otherwise, adultery will be committed only if a man has sexual intercourse outside marriage with another woman who is married. The other woman should be also married. Sexual intercourse outside the marriage with another woman who herself is married, then only it will be adultery. We are not given whether the other woman with whom the husband had relationship was married or not, so we cannot really find out whether it is adultery or not from the facts given in the question. Custodial rape, of course, there is no custody and therefore it can't be custodial rape, so this option C is also ruled out. Criminal breach of trust, that obviously cannot be the answer because it relates to some property. When you entrust some property to another person, then only criminal breach of trust may take place if other conditions are satisfied. So by the process of elimination, the answer is A, cheating. If B is able to prove that A never had the intention of marrying her. So when A made the promise, did he have the intention to marry B or not? That is the central question. If A is able to show that, if B is able to show that A never had the intention of marrying her even when he first made the promise, then only it will become cheating. If initially A had the intention of marrying when he made the promise, and thereafter 3 years or whatever period, if he had a relationship with another woman, etc., then this offense will not be established. As far as our question is concerned, the answer is option A. Yes. How can we call it cheating? I have given here section 415. Whoever by deceiving any person intentionally induces the person deceived to do a thing which he would not do if not deceived, which act causes harm to that person in body, mind, reputation or property is said to cheat. In this slide, I have given only the relevant portion of the overall definition of the offense of cheating. That definition covers so many aspects, mainly delivery of property. Here we are not concerned with delivery of property because no property has been delivered by the deceived party. Deceiving is there if the promise was false, and then she was made to do a thing which she would not otherwise do. So that point has to be kept in mind, that she gave the consent for sexual intercourse only because there was a promise. She would not have given the consent if there were no promise. And this consent which she gave, because of which the sexual intercourse took place, whether this act causes harm to that person. Which person? The person who gave the consent. That is the lady. Does it cause any harm to her? The harm can be in body, mind, reputation or property. No property is involved here, of course. No reputation is also involved. But there is harm to her in mind. She is disturbed. She is agonized. And we can say that the act of sexual intercourse has caused harm to her in mind, and therefore it can come within the ambit of the definition given in section 415. If there is deceiving, the starting point for this definition is deceit. And what is deceit? A false promise is a deceit. So if the promise was false, that is, if the man had no intention from the very beginning to enter into marriage, then of course the consent obtained by him was by deceit, and it will fall within the definition of section 415. Is it clear? All right. So correct option, of course, is option A. Question 7. A journalist was writing an article on rape and murder of a young woman in Bangalore. To humanize and put a face to the story, she wanted to publish the name of the young woman who was subjected to rape and murder. The journalist sought the permission of the parents of the woman because the woman had already died. So the journalist sought the permission of the parents of the deceased, who orally informed her that they had no objection to their daughter's name being published. A published the article in a national newspaper. So there was prior permission taken from the parents of the deceased victim. Now here are the four options: whether A has committed an offense, whether A has not committed an offense. For finding out the correct answer, we need to move to the relevant section. The relevant section is 228A of IPC. Whoever prints or publishes name or any matter which may make known identity of any person, that is the victim, against whom an offence under 376, 376A to E is committed shall be punished. There is an exception to this offence, and the exception is in subsection 2, which says that this provision does not apply if such printing or publication is, and then there are 3 exceptions. I am just mentioning here the relevant one. If the printing or publication is by authorization in writing of the next of the kin of the victim where the victim is dead. In our case, the victim is dead, so this part will apply. And in such a case, authorization can be obtained, can be given by the next of the kin of the deceased, but it has to be in writing. So I have emphasized this phrase in writing because in our factual matrix, it's clearly mentioned that the permission was given orally. The oral permission does not meet the requirement of subsection 2, and therefore this is no authorization. The authorization is not legally acceptable, and the offence under section 228A will be committed if there is only oral authorization. Secondly, this authorization in writing by the next of the kin cannot be given to anybody like a journalist. The authorization can be given only to the chairman or secretary of a welfare institution which is recognized by the central or state government. So even the next of the kin cannot authorize a journalist to publish the name of the victim. If at all, a written authorization is given by the next of the kin, it can be given only to the chairman or secretary of a welfare institution which is recognized for the purpose by the central or state government. In this case, the authorization was given orally, firstly, and secondly, it was given to a journalist, not to the chairman secretary of a welfare institution, and therefore this authorization is not valid. And since the authorization is not valid, printing or publishing of the name of the victim is clearly an offence under section 228A. So the answer, the correct option is option B. It is an offence. The journalist has committed an offence by revealing the name of the victim. Question 8. A magazine published a semi-nude photograph of a woman in a campaign against breast cancer. The tagline of the photograph was to encourage women to get regular medical tests done to ensure early detection of the disease. So this is the object, and the object is relevant. That's why they are telling us the object. A respected lawyer in Delhi felt that the photograph was obscene and would result in young minds being corrupted. Hence, he filed a complaint against the editor of the magazine invoking section 292 of the Indian Penal Code. In the light of the recent Supreme Court jurisprudence on section 292, which of the following is not a standard that should be used to judge whether the photograph is obscene? So the central question here is whether the photograph is obscene. And to decide this question, certain standards have been involved or prescribed by the Supreme Court through certain judgments. There are 4 options as usual. The picture has to be viewed in the background in which it is shown and the message that it seeks to convey to the public and the world at large. So the message and the background is to be considered. Second, if the picture has the effect of depraving or debauching the minds of the persons who may see the picture, it would be obscene. Thirdly, in judging whether a picture is obscene, contemporary mores and national standards should be considered and not the standard of a group of susceptible and sensitive people. And the fourth choice is none of the choices. Now, there have been two recent judgments. Earlier, the Hickling test was applied for determining obscenity. Hickling test is a legal test for obscenity established by the English case of Regina versus Hickling. But this test is nowadays not applied. And the Supreme Court has elaborately explained that the nude is not obscene within the meaning of Section 292 of the Indian Penal Code. Just because the picture is nude or semi-nude, by itself it does not establish obscenity. And the judgment which we are now going to consider is particularly significant because it expressly rejects the Hickling test, and the Supreme Court of India has instead applied the Roth test, which is also known as the Community Standards Test, which was evolved in the US. In contrast to the Hickling test, which was focused on individual or isolated aspects of an entire work that could be deemed obscene, as well as its impact on vulnerable sections of society. Hickling test related to vulnerable sections of society. But under the Roth test or the Community Standards Test, the court adopts what it calls the Community Standards Test, that a picture of a nude or semi-nude woman as such cannot per se by itself be called obscene unless it has the tendency to arouse feeling or revealing an overall overt sexual desire. Only those sex-related materials which have a tendency of exciting lustful thoughts can be held to be obscene. Nudity by itself is not obscenity. Then came the case of Avik Sarkar and another versus State of West Bengal and another in 2014. This is an important judgment, a milestone judgment on Section 292 IPC, Avik Sarkar. Just remember this case. The court in this case observed that while judging a particular photograph and the article of the newspaper as obscene, regard must be had to the contemporary mores and the national standards and not the standards of a group of susceptible or sensitive persons. This is the phrase or the language used by the Supreme Court in Avik Sarkar, and you will notice that in our question, option C has the same language, contemporary mores and national standards and not the standards of a group of susceptible or sensitive persons. And the court thereafter said that we will have to apply the community standard test rather than the Hickling test to determine what is obscenity. So for exam purpose, please remember this case, Avik Sarkar versus State of West Bengal 2014, and the standard which was laid down by the Supreme Court in this case is known as the Contemporary Standards Test, and the Hickling test was discarded. These are the highlights of this case. Further, a picture of a nude or semi-nude woman as such cannot per se be called obscene unless it has the tendency to arouse the feeling of or revealing an overt sexual desire. This we have already seen. Then in 2015 we had the case of Devidas Ramchandra Tuljapurkar versus State of Maharashtra, where also the Hickling test was not adopted and rather the test prescribed by Avik Sarkar was followed. So the correct answer will be all the four choices, all the three choices A, B, C, Option D is the correct option. Question 9. A man was legally married to B. They had 2 children from the marriage. During the subsistence of the marriage, A entered into a relationship with another woman, C. He then proposed marriage to her and they got married at a local temple. C was not aware that A was already married. It's a clear case of bigamy. A, the husband, married second time while the first marriage was subsisting. The second wife was also not aware that A was already married. Of course, we are not told whether A and B were Hindus or Muslims. The question is, which of the following offences has been committed? A has committed the offence of bigamy. A has committed the offence of adultery. Adultery is now no more an offence, so we can straight away rule it out. A has committed the offence of bigamy and also the offence of concealing his previous marriage from C. A has not committed any offence. Now, what should be the answer? These are the facts. A man was legally married to B. They had 2 children from the marriage. We are not told under what system they were married. We are not told whether they were Hindus, Muslims, Parsis, Christians. During the subsistence of the marriage, A entered into a relationship with another woman, C. He then proposed marriage to her. They got married at a local temple. Now here temple word is used, and from this we can deduce that they must have been Hindus. If that is the case, then section 494 and 495 will apply.